All right, so before we go on the record, my understanding is that with Judge Angeline, he had entered pleas and truth,
That's correct, Judge.
and then he was to come back for the outcome of something.
Of a UA. And so he had some food poisoning that day. He'd gone um,
Oh, but
to
let's get the
pre-trial.
record with
Okay, we can do that. Like,
All right.
it's a little bit of procedural
I
stuff.
was just trying to figure out.
Yeah, there's a story.
Okay. All right, the court is calling 2022 CR 1449W State versus Austin Young. Can I have parties announced for the record for the state
Lauren Espinoza.
defense?
Louis Martinez on behalf of Mr. Young.
And are you Mr. Young?
Yes, ma'am.
All right, on September, I think this is September 11th. You
Yes,
entered a
ma'am.
plea of true to violations 2, 2, and 2. And there was no sentencing on the plea. Off the record, your attorney informed me that you were requested to do a UA or
A
something.
UA,
Yes.
the 11th.
All right, you may proceed to counsel.
Okay, so Judge, just procedurally. So on the 11th, Mr. Young was released by Judge Angelini to go to get UA. And essentially told him in open court, if you clean tomorrow, then, you're just going back on probation. I'll reinstate you. If you're dirty, then you need to go in someplace. Mr. Young called me from pretrial services. I was on the phone with him. We were trying to talk to somebody there about him doing a UA. They kept saying, we don't have anything from the court, so we had trouble doing that. The next morning, Mr. Young had some food poisoning issues, had been at the doctor's, did not come in, a warrant was issued. And then we just tried to regroup and figure out where to go from here. And so Mr. Young brought himself in voluntarily yesterday. One of the things that we needed to address, that we'd addressed with the court, with Judge Angelini, is that in May, Mr. Young was having some mental health issues and some kind of mental health emergencies. And that was kind of the reason for the non-compliance in May. I've got his mother here to testify to that. And so I'd ask the court for to allow me to bring her up and kind of explain what was going on. Okay.
You need to step over there.
Yeah.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Wendy Scholmer,
All right, and can you spell your last name for the court reporter?
SCHORLEMER.
All right, defense, you may proceed.
Ms. Schuler, obviously you're Austin's mother.
Mm-hmm.
Can you explain to the court what was going on with him mentally in May and what our issues were?
He had, looking back, shown signs of depression, but I didn't know that's what it was. He was not eating a lot, not active. He had a lack of energy, in bed a lot, depressed. He was looking for jobs and getting no luck at all.
Okay, let me stop you there. So he was looking for employment, and obviously the biggest issue is his criminal history.
Yes,
Okay.
the record.
Right.
Nobody wants to even open the door to him.
And what effect were you seeing on him mentally?
He, looking back, was completely withdrawing and kind of having a mental breakdown.
What kind of signs did you see of him having a mental breakdown?
Withdrawn from everybody.
Did you seek out any kind of medical help from at the time?
Yes.
And what kind of mental help did you seek out for him?
I took him Sunday. Friday was when I really noticed something was not right with him. He was kind of talking, saying crazy things, not crazy, but just not appropriate things, not in the here and now. And so on Sunday, he was not sleeping either, not eating, not sleeping. So on Sunday night, I ran him up to a little local ER, Methodist ER in our neighborhood.
Okay.
And they did a history, and not a physical, but just talked to him, this cool doctor from Austin, and said, well, maybe you just need to get some sleep. And I was very shocked at the lack of care or concern, but of course I'm his mother. So he said, well, let me give you something to sleep. So he gave him one Ativan. And by the time we got to the car, he was relaxed and he slept that night.
Yeah.
Monday morning, he woke up and became very agitated and talking out of his mind and not eating and just not himself. So then that went on Monday. Monday, we came down to see you.
Yes.
Because I knew he had court Tuesday and I knew he couldn't do it. He wasn't sleeping. He couldn't get dressed. He was a mess. So Tuesday, I took him back. I went to a Stone Oak Methodist Hospital ER.
Okay.
And we waited for hours. And kind of the same thing, a little bit more concerned, but not much. And we sat in a room for hours and the doctor did do some blood work. No blood work, did a urinalysis. And then they gave him something and it made him much worse, much more agitated. At that time, they called in a Bexar County, I guess, policeman or sheriff. I'm not sure who he was, but he was very kind. And he talked to Austin and said, they don't have the facilities here. They don't treat psychiatric patients, but we can just take you in the ER and the ambulance straight over to Methodist Specialty where they can help you.
Okay, and let me stop you. And so was he taken over to Methodist Specialty?
No.
Okay.
He said, no, I'm fine. He said, I'm fine. I said, no. I looked at the policeman. I said, no, he's not. And he said, well, we can't force him to go and you can't either. He's an adult. So they gave him something, made him, I said, he's got to have something to sleep. I can't take him home. He's pacing the floors 24/7. So they gave him one more Ativan. And I said, could you please write him a prescription for just 2 or 3 until we can get to see a doctor? And she said, no, you have to go to Methodist Specialty. We are not a psychiatric hospital.
Okay, let me stop you there. And it's kind of subsequent to that is when we started coming to court and we've had these, the issues with the warrant, those sorts of things.
Yes,
Okay.
yes. And then
And so,
that's you have to come.
okay. Now, had you ever noticed him have kind of a psychological breakdown like that before?
Yes, once before
And when was that?
in high school.
And what were the circumstances of that?
He was having a very difficult time getting through a math class that was required for graduation. He had lots of learning disabilities and he was being bullied and all of a sudden just stopped eating, wouldn't go to school, completely shut down.
Okay. And this situation seems to be kind of consistent with that.
Yes, but the pediatrician at that point helped us and gave us something to get him through it. And with the principal's help and the special education department's help, we were able to get him out of the high school and into a alternative school to finish his requirements to graduate early.
Okay. And so these are the issues that he's been having for the past several months, correct?
Yes.
Okay. And a lot of it is the fact that he's trying to move forward and he's kind of running into roadblocks every chance.
Yes, he can't. He's getting through his probation pretty well in his recovery program, but he can't be a productive young man. He cannot get a job.
And you see the stress that puts on him.
Oh, yes.
Okay.
I mean, he one day he said, Mom, there's no hope for me. I might as well just end my life.
Okay. I'll pass the witness.
Any questions?
Briefly, Your Honor. Hello, Mrs. You stated you observed these types of signs prior to May 25. Is that correct?
Yes.
Approximately what year was the high school incident?
Oh, when he was, let's see, I guess about 18.
And he is how old now?
I'm sorry,
How old is your son now?
39.
So how many years would that have been? About more than 10?
Yeah.
Okay. To your knowledge, did Mr. Young ever acknowledge these signs that you observed in him?
Did he acknowledge?
Mhm.
No,
Okay.
he said, Mom, I'm fine, I'm fine, I'm fine.
And is that in both 2025 and when he was in high school?
I don't remember high school.
Okay. To your knowledge, did Mr. Young inform his probation officer of these issues he was having?
Yes,
Okay.
he
Did you,
talked to him numerous times about the issues of employment. He said, told him to go to Goodwill.
Mhm. But I'm speaking of the mental health.
Oh, yeah.
issues.
I think so. And he discussed, maybe he informed him that he was on a antidepressant.
Mhm. But you're not positive of that, or you are?
No, I'm not.
Were you aware of Mr. Young being on probation?
Yes,
Yes. Were you aware that one of his conditions is to submit to drug testing?
yes,
Were you aware that he violated that condition?
yes,
Would you agree with me that the best way for someone to learn a lesson is to take accountability for their actions?
yes.
No further questions, Your Honor.
And just very briefly, Austin still is on a alcohol monitoring device, correct?
Yes.
And he's on probation for DWI. He does not drive anymore.
No, does not have a car and does not drive anywhere.
Okay, so he gets rides or Ubers or
For
walks.
me,
Right.
me.
Thank you. And so, to the best of your knowledge, he is not picking up new offenses, correct?
No,
And to the best of your knowledge, he's reporting to probation.
yes. I know that he missed one time
Okay.
on a Thursday afternoon.
Yes, ma'am. I'll pass the witness.
All right, thank you so much for coming down. Thank you. All right, so here's the court's issues.
Okay.
One, this is not his first motion to revoke,
Correct.
and it's not his first motion to revoke for violation of condition number 2. And it seems every time there is an issue with probation or there is a potential revocation, he doesn't show for court. And something else has popped up where he can't show. And it appears that his issues are the consequences. So I don't know if there's a reason to continue him on probation, because I don't know if there's anything that we can do to help him.
The judge, I'd like him to do UA today if the court would do that. I would, obviously there's some mental health issues. Obviously he's struggling, but I think that the main, there's a lot of things that we ask people to do on probation, but I think the two main things we ask them to do is not break the law anymore and to report and allow themselves to be supervised. And he certainly has been doing both of those things. Our biggest issue when we get DWIs in felony court is the fact that it's not your first DWI.
Mhm.
By definition, it's not. And if you're willing to get 3 DWIs, then, there's an issue. And I think that the most, important thing he's done for accountability is just decide never to drive again. And that's good. That keeps the community safe. So the issue now becomes, how much work do we want to put into him, right? Because, we've got some compliance here, and I think we've got substantial compliance. But if our question is how much more help can we give him, I think that we can. I think that he benefits from the structure. I think he benefits from the supervision. I think he allows himself to be supervised. But, it's not easy to be on probation. It's not easy in this society to have a criminal history because you don't get the same chances other people do. And I'd ask the court to consider a sanction other than revocation. I'd ask the court to consider, there's a recommendation for state ISF cognitive track.
Hasn't he been in
He,
a facility
I think
before?
he's been to SATF before, but I mean, we're talking about some cognitive skills. And the main thing is we need to put him in a position to work. And I think if, like with most people, if he's working, we're not going to have problems with him showing up to court. We're not going to have problems with him showing up to probation. If he's working and he's productive, I think that we're going to get, if not perfect compliance, then pretty close to it. Because he's not a person who is out breaking the law more. He's not a person who is refusing to go to probation. And, in fact, as the court knows, he came in yesterday. He knew he had a warrant. He knew he had missed. He knew this was an issue. And it's not like he went ahead and hid out until he got picked up. He came in to take accountability, to go head on and face his actions. And we know that this court is really good about trying to craft conditions of probation that help a person be successful. And so I'm asking the court to consider that in this case.
All right, state.
Your Honor, the state echoes the court sentiment that this is not the first MTR or violation of condition number 2. There is consistency in failing to take accountability. We'd ask that you'd grant the state's recommendation to revoke. Mr. Young was given opportunities to comply with probation and take full accountability, but we would urge that partial accountability is insufficient here. He was explained his conditions of probation, and he has shown that through his actions and subsequent violations and then subsequent FTAs on 9/12 and 9/23 that he's still not taking accountability for his actions. So we'd ask that you grant the revocation.
All right. This is what the court is going to do. The court is going to revoke. The court will sentence you to 3 years in the prison, give you credit for any time served, 2-year license suspension. I'll request the therapeutic community. There's a $1,500 fine, time and money to run concurrent. I'll give him credit for any successful completion and inpatient treatment.
Okay.
And let me see. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
The form that we signed when Judge Angelini was here, did you review that form with me when you signed?
It's the
Yes.
form
Yes.
telling you whether or not you have a right to appeal. You do have a right to, you have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you're on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes.
All right. So we can go off the record. So Mr. Young, it's just that the court has worked with you by giving you inpatient treatment and giving you different treatments to try to help you. But at some point, there is nothing else that I can do. I don't have any more tools. It's sad that the legislature doesn't have more to offer, but I have what I have, and that's it. So you'll receive the credit for any time that you've served, okay?
And
Thank you.
and would you allow him to say anything to the court right now?
I'm sorry?
Judge, would you allow him to say anything to the court right now?
Sure.
You want to say something, Judge?
I don't know what to say, Liz. I'm shocked. I've done everything. I'd finished all my probation stuff. I was just waiting for my, my probation to be finished. I've done all my classes, paid for fine. I had done everything. The only reason I had another MTR is that we had lost the monitor and I couldn't afford to pay the $3,500, and you gave me this
So
thing
here's the
for
problem.
90 days, and it's been
This is
over
the
a
problem.
year.
This is the problem that you're not understanding. You had a violation of condition number 2 previously with the court. You pled true to it. I found it true. And I gave you conditions to address that violation. And then you come back and you have the same violations. So when you have the same violations, which were violations of condition number 2, we have nothing else.
Well, that took a turn. Out of East Baton Rouge Parish Prison, we had not 1, but 2 parole revocation hearings, and each one landed in a very different spot. First up was Kim Farrell Ross, and his situation was layered. The allegations started heavy, aggravated burglary and aggravated assault, but by the time we got into the weeds, it had been reduced to trespass, with Ross himself admitting that he was on drugs and homeless at the time. He explained he lost his leg in an accident, was using a wheelchair, and took shelter under a stranger's carport when it was raining. He did admit that he didn't have permission, and the board pressed him on why he thought that was acceptable. He didn't try to duck responsibility. He said flat out he was wrong, took fault, and pointed to his drug use as clouding his judgment. Still, the panel wasn't having it. They pointed to the continued criminal behavior while on supervision, plus years of unpaid fees, and concluded that revocation was the only realistic choice. The vote was unanimous, and although they wished him luck moving forward, it was clear that honesty alone wasn't enough to offset the violations. The second case was Saria Hardiman, and here the tone shifted. His list of alleged violations looked long on paper: firearm by a felon, stolen firearm, paraphernalia, intent to distribute, obstruction, the works. But he stressed that most of those charges had already been dismissed. What remained was one marijuana-related count with a court date coming up just weeks away. He pled not guilty across the board and asked for a continuance so the criminal court could sort it out before the parole board took action. The board took that request seriously, and instead of rushing to a decision, they granted the continuance. That shows a level of patience and deference to the pending trial process, something you don't always see, but makes sense when the case is unresolved. Hardiman also mentioned he wasn't from Louisiana, almost as if to say, this isn't my usual environment, but the board didn't lean into that. They simply held off until after his court date. The judge's demeanor throughout was calm, orderly, and even a little understanding. With Ross, they showed patience, but kept circling back to the core issue. You can't keep violating conditions and expect supervision to continue. With Hardiman, they respected due process, acknowledging that pending charges should be cleared before making a final call. The atmosphere was steady. No raised voices, no grandstanding, just the board methodically applying the rules. The two outcomes highlight how parole hearings can cut in opposite directions. One individual revoked after multiple violations and years of struggle. Another granted a continuance because the allegations still need to play out in court. Both decisions were grounded in the facts presented, not emotion. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.